You were in the Supreme Court chamber today listening to that argument. What you spent years as a law student studying Supreme Court cases and years as a law professor teaching Supreme Court cases. What do you make of today's?
The court's job, by contrast, is to understand how to read the statute and apply it to the facts, in this case, the extraordinary facts of January 6th. So I did take note of that they were focused on the consequences, very much on who these protesters were, on the peculiarities, the fact that we haven't had a situation like January 6th before. But look, we have had other kinds of criminals in our country try to disrupt our government and engage in things, whether it's witness tampering, threatening witnesses, destroying evidence, and trying to interrupt the certification of an election, to me, clearly falls under the statute at issue.
Oh, that's gonna hurt!
Let's break down the Supreme Court hearing where, yes, the conservative justices, in particular, Justice Alito and Justice Gorsuch, comparing protests, peaceful protests, to what happened on January 6th and saying if they allow this section of the law that deals with obstruction proceedings to apply to January 6th defendants, then isn't it going to apply to, and then Justice Gorsuch gives the example of somebody pulling an alarm, as we know that was a Democrat, and Justice Alito giving the example of stopping the Golden Gate Bridge, which we know those were liberals. So it's not an accident that they used examples that were from liberals or Democrats, because they're trying to say here, if you want to apply this to Republicans, then surely you're going to apply this to Democrats. And this was a very kind of stunning admission on their part of the politics at play here.
One of the things the United States Solicitor General drove home again and again, which is incredibly important for Americans to understand, is the statute requires that the criminal defendant have acted corruptly, wrongfully, knowingly. So if we had somebody who was protesting, thought they were protected by the First Amendment, but they actually weren't, that wouldn't be covered by this. The emails from Mr. Fisher, the messages he sent about the gallows, sending Democratic Congress members to the gallows, all of those emails, all of that evidence is necessary to bring a case under this statute. So there are very, very strong protections here to make sure that somebody who's expressing an opinion, even an unpopular opinion politically, would never face prosecution under this statute. You have to intend to stop the government from conducting its official business and to be acting intentionally to do that.
Because usually these Supreme Court justices do everything they can to seem above politics. Especially on the more recent years, they have been appointed in a very partisan way. I mean, when Ruth Bader Ginsburg was appointed to the Supreme Court, all but like 2 senators voted for her. It was, even though she was considered liberal, it was almost unanimous. But that has certainly not been the case for the past few justices. They have been voted on in a very partisan way.
So look at it this way, right? Donald Trump actually had only 2 accomplishments in his 4 years. And one was the extremist Supreme Court that overturned Roe versus Wade. And the other was more than $2 trillion in tax cuts.
But they tried to act as if they are above the partisan, which they should be. It is a lifetime appointment. At this point, it shouldn't really matter who has appointed them. But the fact is, they were appointed in such a partisan way, they no longer have to, that's just how they believe, right? And so here we are, this speaking politics in a way without trying to speak politics, but we all understood the politics. At the end of the day, they were trying to compare peaceful protests and maybe being done in a way that you don't like, comparing it to the really violent protests on January 6th. And they weren't even just protests. I don't actually like to use that word because they didn't just remain outside the Capitol and incidentally, maybe somebody got hurt. They were planning on going in to the Capitol.
The only time I've seen an institution overrun by violent criminals was here in the U.S. Capitol on January 6, 2021, an event that gentleman described as a tourist visit and has consistently likened it to a tourist visit. So I don't know that he's going to be the best and most reliable witness for determining when in institutions being overrun by violent criminals.
The defendant, Fisher, in this case, whose case has gone all the way up in front of the Supreme Court, had said, if we kill them, they can't vote. That's literally what he said. So this isn't a matter of protesting. He didn't say if we're outside loud enough, maybe they will change our mind. No, this was about going in a violent way and stopping the peaceful transition of power. And the Solicitor General makes this point in an excellent way because Justice Kavanaugh says, well, don't we have enough laws otherwise to handle this kind of situation? Our assault laws, because it is true, a lot of them were also charged with assault because they were assaulting Capitol police officers. And so can't you, prevent this type of crime by charging in these other laws that are used more routinely? And she gave, I thought, such a great answer, which was like, sure, we can charge them with assault if they committed assault. But they, in addition to committing assault, committed a very specific crime for which they should also be charged. Going in and trying to stop the peaceful transition of power in itself cannot be charged in another way because of the way they did it. They did it to obstruct a proceeding. And so that's why, you could have another charge such as assault, but shouldn't that be able to be charged? And if you're going to take that away, then what they did, corruptly going in and trying to stop a peaceful transition of power by stopping a proceeding, just can't be charged criminally in this country.
Let's be clear on this point. It wasn't just that they asked for a pause. The president specifically asked me, and his gaggle of crackpot lawyers asked me to literally reject votes, which would have resulted in the issue being turned over to the House of Representatives, and literally chaos would have ensued. So
conservative justices are so worried about this being applied too much. I think they should be worried about this happening too much on January 6th because somehow we don't have criminal laws that stop it. Like, that is worrisome. And Katie Porter makes the point so well, and it's true. Like, at the end of the day, it's not just an obstruction of proceeding that the prosecutors need to prove. They had to prove that it was done corruptly. They have to prove that there was this intent to do it corruptly, not just that we thought we had First Amendment rights and we were stopping it, or even in a minor way you were stopping it or incidentally stopping it. Maybe that wasn't even your intent. They did have to prove that there was a corrupt intention to stop the proceedings. And really the only, we had the Justice Sotomayor and Justice Kagan wanting the provision to be interpreted broadly in order to be able to hold the January 6th defendants in account. And we had the Justices Alito, Justice Gorsuch, Chief Justice Roberts, really wanting there to be a limit on how that is interpreted. Justice Kavanaugh barely asked any questions, so it was a little bit hard to read him. But interestingly, Justice Amy Coney Barrett and Justice Ketanji Brown Jackson were in lockstep in their interpretation. And I thought it had such an amazing interpretation of it that could kind of solve everybody's problems. And if they can get 3 justices on board with them, they might be able to still hold the January 6th defendants to account for their activity that day. It's not going to be easy because there is really a broad disagreement about how this should be interpreted. It's certainly not going to be a unanimous or even close to unanimous decision. But if they can get 3 justices to their side, they can make it happen. And what they did in their dissection of it was basically say that it should be applied because this had to do with stopping the delivery of the electoral certificates to the congressional proceeding. Because the first part of the section has to do with documents. And so they're saying, this still has to do with documents because the document at issue is the certificates, the electoral certificates, and they stop them from going to the vice president to be counted. So we don't have to answer the question of whether or not this would have to do with a general protest, because this wasn't a general protest. This was stopping the availability of the documents. I thought that was an amazing way those two women interpreted it. It should be the way the Supreme Court moves forward on it. It's both broad enough and narrow enough, I think, to address everyone's concerns.
Real quick, Meta just changed their algorithm to suppress political content. Please follow our Instagram at MeidasTouch right now as we head towards 400,000 followers so you don't miss a beat.